Hello, everybody. Hello, everybody. We're ready to start a couple rounds of more sessions here in the Creator Lab. This one is going to be super fun. Anytime you get 4 lawyers together, it's going to be interesting. They've all promised me that they won't impeach each other and that they won't talk for longer than 10 minutes each. So we hope that's going to happen. But this session is about legal landmines, how to protect your content, how to protect your career. Y'all know if you're a creator, there is so much going on legally that you need to know about, and you probably don't. Contracts, copyright, content rights. The legal side of being a creator can be full of pits and landfalls and avalanches and everything else. So here we've got 4 great creators that are doing stuff and have led their career in doing stuff with creators. And we're going to talk about how to protect yourself, how to keep control of your work, and hopefully give you a little bit of a legal survivor guide here with some practical strategies and maybe a couple of horror stories as well. Now we're going to do this for about 30 minutes, and it'll be a fast pace, but then those of you who want will go over to Studio C over there, Stage C, and we'll do a little AMA. So if you want to ask them questions, if you want to talk to each other, that'll all happen there, and we'll have another session in here 10 minutes after that. So I am so excited to have here our moderator, Heather Rafter, founder and principal at Rafter Marsh, but also former general counsel at DigiDesign, which is now part of Avid. So Tyler Chou, CEO and founder of Tyler Law for Creators, who also happens to be my manager, which is really kind of cool. Can't believe she puts up with me. Eric Farber, CEO and founder of Creators Legal. Chelsey Mori, founder and CEO of Unbound Legal. Heather, it is your session. A big round of applause for all of these lawyers. Thank you very much. Take it away.
I like how they're testing an audio person with a microphone usage. All right. Hello, everyone. I'm Heather Rafter, and you already have our bios are there. And we are here to have a very exciting session covering everything you need to know about the law and how it's evolving for this new creator economy. I'd love a show of hands, please. How many people here are creators? Okay, how many are in what you would call the new creator economy? Okay, how many a little bit more traditional with broadcast? Thank you, more traditionals, for honoring my Avid past. Okay, and how many support creators? How many are here as managers, legal, accountants, all of the above? How many of you are creating platforms that are going to be used in this economy? Wow, what a great thing. And how many of you are tool creators? We've got it all covered. All right, I hope that's helpful. So I thought we would start off today and hold us. Someone have a time clock. If any of us go over 60 seconds, you let us know. Okay, we're going to start off with a quick overview of the legal system. This is the first time anyone has tried to summarize copyright law, proprietary rights, and rights of publicity in under 4 minutes, but take it away.
Okay, I'm going to talk about copyright.
And one thing I was going to say is everyone here are innovators in providing legal services to meet the needs of the new economy. And so I'm just really honored to be with this group. So Tyler?
Thank you, Heather. I'm so happy to be here. So copyright law and fair use. So let's just clear this up. Fair use is not a thing that you can slap on your videos and say, I get to use your clips. Fair use is a defense in litigation. So if someone wants to put a copyright strike because you use their clip in your B-roll for your YouTube channel, they can. And YouTube these days will not step in. They'll let the IP holder put the strike on you. So be very careful when you're using someone's clip and thinking, well, I can use this because it's fair use. And in connection with that, let's talk about AI and fair use, because everyone is waiting for the courts to decide, and the developers, the machine learning developers are wondering, well, our defense is this is fair use, so we can learn on all of your content. And we just had one case, Thomson Reuters, which the court held that it was not fair use. So I think in the next year or two, a lot of judges and lawyers will be deciding the fate of the developers and what really is fair use. And so I think it's a very exciting and interesting time that we're living in right now.
Okay. How many of you have actually filed a copyright registration? All right, would you like to hear another quick little summary about what you can and cannot copyright? Can you try to grab that one?
Sure. When you put your videos up on YouTube, Instagram, TikTok, it's automatically copyrighted. So you don't actually have to go to the copyright office. Now, if you're making a 2-hour film, which some people do on YouTube, you should definitely go copyright that. Coming from 20 years in Hollywood, every time we finished a feature film, we would go copyright the final script as well as the film. So that's just kind of how you can think about what you should copyright or not.
Okay, there also is something called rights of publicity, which is getting more and more prominent as AI encroaches in a bunch of different areas, including deepfake. You want to talk a little bit about that legal doctrine, rights of publicity, and how it's maybe evolving? Eric?
Sure. So I am going to add something to copyright. The easiest way to explain it is copyright protects the expression of an idea and not the idea. So you may have copywritten the scripts, but you can't actually copyright a script. You can copyright a book. You can copyright the final movie. But that's where copyrights are attached to. And there's registered copyrights and unregistered copyrights. And copyrights are happening so fast. Stuff is being created so fast. The video that's being shot on the phone right now by Rox here, that can get a copyright, and as soon as he publishes it, he owns that copyright. Now, we have rights of publicity, each one of us, and everybody out there, you all have a right of publicity of your person, your name, your image, your likeness, the cartoon figure of you, and your voice. And you own that. And while you're alive, you completely own it and you get to control it. So, but there's, and if they wanted to get really technical, you could say, I don't want to be on camera. And you have to get a release for my right of publicity. And that's really what they're actually releasing. And sometimes you walk in, if you ever lived in LA, you walked in and to a restaurant and it says, we're filming tonight. If you walk in, you're releasing your right of publicity. Now, for about 20 years, I protected rights of publicity. That's what I actually did as a lawyer before I started Creators Legal, which is a non-lawyer platform for documents. But I protected the rights of publicity of dead rappers, Tupac and Biggie and Eazy-E, and then other rappers too who are alive. Biggie died in New York. There's no post-mortem right of publicity in New York. So somebody could actually do a T-shirt with Biggie and sell it. But Tupac died in California, and he lived in California, where we do have the Fred Astaire Act. I think it's Fred Astaire that made sure that his widow made sure that there was a right of publicity post-mortem. So when Dre created a hologram of Tupac and did it at Coachella, he had to come to us to get the right of publicity to actually put that hologram up. And when he sang songs, he had to go to Interscope and to Amaru Entertainment, which was my client, to get the right to use those songs. And that's the basic right of publicity, and that's changing daily in the world of AI because there's so many ways to use images to create.
And there's an evolving sense that the right of publicity doctrine will really be important in shaping rights.
100%, because as you upload things, remember there's all sorts of terms and conditions that you're clicking yes to. Now is when it matters, and over the next 20 years.
So, and just to add to the copyright discussion, there are some advantages of copyright registration. Eric got a little bit granular on the difference between registered and unregistered for purposes of litigation and recovering of damages, but we don't have time to get into all of that, but we're happy to go into more depth in the Ask Me Anything session. All right, we have not heard from Chelsey. Would you like to add anything? Maybe there's something called contractual rights, of course, right?
Sure, just basic contractual rights?
Sure.
All right, so we're here at a creator economy panel. So the biggest things in contracts for creators that everyone should think about is creators own the internet. So for C, it's all about capping your liability. That's one of the first things I'd look for in a contract, is making sure that your liability for that deal isn't going to exceed what you're actually being paid. So for own, I would always, Control F and go to that ownership paragraph and see, are you owning the content? Is the brand trying to make it a work for hire and then they're allowed to use it in perpetuity? I would cross that out and make sure you own it and grant them a license. T, creators own the internet. So T would be for a termination fee or a kill fee. So a lot of my clients, they get involved with a brand and all of a sudden the brand wants to cancel the campaign. And I always like to put in there that, if they cancel it after you've signed the contract or, within 30 days of the anticipated post date, maybe you get 50% of the deal and then you try and refill that slot with another brand deal. Or if they cancel it within 7 days of when you were supposed to post it and you've done all the work, then you should get paid 100%. So that's called a pay or play clause. The last thing, creators own the internet. For I, it would be indemnification. Basically, that means if the other party screws up and it's their fault and you get sued by a third party, let's say you were advertising a product, there was something wrong with that product, and then you get sued because you advertised it, the brand would have to cover all of your court costs, all of the damages. And brands always put that in for themselves to make sure you're indemnifying them if you say anything wrong. But you always want to make sure that's mutual, the reps and warranties are mutual. So whenever it just says, you're doing something for the brand, I'd always just ask to make that mutual throughout your contract. And to piggyback one more thing on the copyright, which is cool, the benefits of having a registered copyright were really to help with takedown notices in the past. There's a lot of new cool AI tech. One is called LOTI AI, LOTI, that basically scans the internet every day for your likeness and for your voice. And it can pick up impersonation accounts and deep fakes of you, and it's actually a free service. There's paid portions for more takedowns, but as a starter, you can see what's out there on the internet for you for, impersonation accounts, counterfeit merch, how your likeness is being used. Even if it's just a partial print of your eye, they will find everything. And they will take it down for you, and that's an automatic process, so you kind of don't need to issue physical takedown notices anymore. They go to the platform, to the domain, to the credit card processor, and they just do it all automatically with AI.
All right, thank you. I wanted to thank Jim, who's now stepped away, Jim Louderback, who put together this panel.
He's over there.
Okay, there you are. I really wanted to thank you for putting us all together. And in his words, the goal now is to educate creators and those who support creators on how to safeguard their content, brand, and revenue stream in this time of evolution of technology and uncertainty in the law. So let's start with mistakes, and then we'll build you all up on how not to make those mistakes. So if each of our panelists could rattle off some of the biggest mistakes they've seen. Who wants to start?
I can start. So I represent some of the biggest YouTubers in the world as their part-time general counsel and fractional CEO and COO. And you would be surprised how many huge creators have not trademarked their names. I mean, it's just shocking to me.
Trademark. Explain a little bit there.
Well, you need to trademark your name, your handle of your YouTube channel, your business name. I have a client who's been with me for a year and a half, and I was chasing her to trademark her name. And she just wouldn't do it. And I didn't know why. So she finally came to me like a month ago and said, let's do this. So we finally went to go check. We were starting the application process.
So and she's talking about registering a trademark with the USPTO, right?
And you know what? 2 months ago, someone registered her name. So now we have to go oppose the application, which will cost, it's basically litigation. It's going to cost her probably 5 to 6 figures to go and oppose this. And honestly, it costs a couple $1,000s to register a trademark. That's how much I charge my clients. And had she just done it 6 months ago, she would have her name protected. Now, we can oppose it because she has use in commerce. She's been using it for 5 years.
And it's her name, right?
Well, it's her nickname, basically. But it's a very common, but she's been using it for years. And I finally asked her, I said, what took you so long? And she said, well, I was scared of the process. Because it's very daunting, the idea of, trying to figure out the right name and doing the application and potentially getting office, actions if the office needs more information. But I said, well, I'll just do it for you. That's why you hire an attorney. And so that is one of the biggest mistakes that I've seen. And then also just partnership agreements. Don't start a channel with your best friend with no agreement in place. Leslie's laughing. Like, I've exited 6 partners in the last 7 months, and they're huge YouTube channels, you guys. You would not believe who they are. No agreements in place.
Okay. One thing that I think you would be interesting for people to know, there also is a way, if you want to test trademarks and you're thinking way out ahead, it's not that easy to think that way out ahead. You can file an intent to use application versus an actual use application. Thoughts on that?
Yes, so definitely if you are not using it yet, let's say it's not on your website, you're not actually using it in commerce, you can do an intent to use. I actually just filed one for myself because I'm starting another new business, and so we're just going to file it, but now it will be protected because it's a pretty common name. And so if you have a great idea that you think someone else might grab, file an intent to use, and that will put you basically first in line because you have submitted the application.
Okay. We're almost halfway through. Other mistakes you might have seen, Eric, in your several years of law practice?
Contracts to me are really about a great relationship. They are the roadmap for a relationship. I say, I'm going to pay you to do this for me, or we're going to be partners, and I'll do this part, and you're going to do that part. And people go into relationships without that roadmap, and so it's sort of like high fences make great neighbors, right? Contracts make great relationships because everybody is on the same page before they get started. And having those contracts are really, really important, exactly what Tyler is saying. At the same time, I love to tell this story because it's just, I had an extreme athlete client, and he used to do wingsuiting and climb Mount Everest, and he actually held the record for climbing up and down Mount Everest. And then he got into wingsuiting, and he did hundreds of hours of wingsuiting, and he had a cameraman. The cameraman is the one who actually holds the copyright. The person who's holding the camera holds the copyright. I'm sure all of you have heard this, and all of you know that. So you need a work for hire, you need a contract to transfer that. And we had all this footage, hundreds of hours, maybe thousands of hours. Somebody came along and wanted to license it. It's the type of stuff that they play in bars and on airplanes as filler content. And right around then, and I kept saying you always got to have these contracts, his cameraman died in a wingsuit accident, and his widow refused to sign. So where is all that footage? Sitting on a shelf. So get contracts early because they set the relationships up for a good experience. And an email back and forth just isn't good enough. That's the beauty of the contract, is the relationship and how it creates it. Okay. So rather than a mistake, it's a positive note on contracts.
Before we get to Chelsey's list of biggest mistakes, quick question. How many of you in the audience actually use lawyers to review your agreements and for IP protection? Okay. Panelists, really quickly, do you need a lawyer?
Quick answer, or 111?
111, rapid fire.
Sometimes.
Eric?
Yes.
Absolutely not.
Okay. How many of us are interested in hearing a longer explanation on this? Folks want to hear it? Okay. Defend your position, each of you. 30 seconds. Go.
Okay, I'll start. Not everyone can afford a lawyer. I get that. Maybe you're just starting out, and I like to say it's kind of like a spectrum from a donut to a frozen microwave dinner to like a home-cooked meal. And maybe the donut is just, we're sending texts back and forth, at least the main points are in writing. I've had people that had far worse than that. Maybe the the frozen dinner is like, okay, I've been on ChatGPT, or I'm using a template from the internet that isn't tailored to me at all. And then maybe the lawyers, when we're getting pretty specific and it's absolutely tailored to all of your needs and everything is in there and everything is set forth and you have exit strategies and you know what to do. So I think, yes, of course it's always good to have a lawyer. I'd also like a giant mansion. But when you can't, you have to figure out ways to protect yourself. But beyond just saying, I'll get a lawyer in 10 years when I'm big enough, you still need to be taking proactive legal steps and figuring out what you can do for yourself. So I know a lot of you are using ChatGPT. In my practice, I just created a redlining, like a contract review redlining tool in track changes that you just press apply based on actual attorney comments, because the ChatGPT, it doesn't work for me. I don't know about you guys, and I'm like trained to do this, and it's not that helpful. So, but it's better than nothing, you know. So just at least read the contract, dumb it down in ChatGPT, and find out what you're agreeing to.
Okay, Eric.
The legal profession has failed the vast majority of people in America and people around the world.
That's very broad.
100%.
None of us, just to be clear.
No, well, you guys are still practicing lawyers. I have no interest in practicing law anymore. I have an interest in serving 10,000 clients at a time, and so I built Creators Legal. I mean, look at some of the largest platforms in the world, LegalZoom, Rocket Lawyer. There's dozens of them, and the whole mission of them is to provide legal services without lawyers at a fraction of the cost. Creators Legal is that for the creator economy. We've got hundreds of templates that are vetted by lawyers and all written by lawyers, and it takes you 10 minutes to fill them out.
Okay.
And that is that. So for the vast majority of people, you don't need a lawyer.
Okay, Tyler, meanwhile, has a rapidly expanding group. You're up to 8 lawyers now?
I have 8 employees, yes, 2 lawyers.
So someone thinks they need lawyers.
Look, I think a lot of people come to me and have half an hour session, and I can knock out a lot of their questions. And I think, you know, what you guys are saying is right. You do need to be thoughtful about what you're signing. I after 20 years working in the studios in Hollywood, you know, I left Hollywood because I believe YouTube is the new Hollywood to come protect creators. So many creators have gotten screwed signing agreements they should not have signed with the big companies out there that you guys know who I'm talking about, so predatory. I do think you need to have your agreements reviewed by an attorney. Now, I also understand that not everybody can, afford an attorney. You know, I'm about to launch a free community to creators. I basically think of it as my big creator clients are paying for the small creators who can come to my free community and ask me questions. And that's what I want to give to the creator economy, is an ability to ask me questions once a month, and you can bring me all the questions you have, and I will answer them. And I think that's really important, is giving that baseline free advice to people.
All right, in our remaining 9 minutes, quickly, thank you, your thoughts on the biggest mistakes.
I'll give quick ones. If you ever see the word liquidated damages, cross it out. It basically just means it's some arbitrary penalty that if you breach it, maybe you have to pay like $50,000 per breach. Always cross that out. First rule law school. Perpetuity, if you ever see that, just be very careful. Like you're literally giving your rights forever, worldwide, in perpetuity. I'd be very careful with that. And also I'd say if contracts are silent on AI right now, I haven't seen very many at all mentioning it. I would just put some new blanket provisions in there saying, you know, don't train on my AI. Don't license my content to third parties to train on AI. Let me embed. There's signals that you can embed in your content now that are metadata or watermarks that signal no AI. And some AI models actually respect that and don't train on it, but at least you're making your intentions known. And so you can put something in there like, I reserve the right to embed that into my content, and you're not allowed to remove it. And then at least it's a little bit tracked wherever it goes on the internet. And there's some services like Nightshade that actually poison AI models if they're using that training. So there's a lot of really cool resources out there. I'll cut it at that for time.
I'm going to jump on that really quickly. Also realize that some of the platforms have automatically opted you into AI training. YouTube and LinkedIn are 2 of them. So you actually have to go opt out of it. I'm actually disappointed in the platforms that they've done that. So make sure you go opt out, that they cannot train on your content.
Eric, everyone wants to know, and we discussed this really briefly. Sorry about fading in and out. What can you protect? If you're using some AI, what is the rule of thumb on what content can you protect in copyright?
Look, this is still a developing area, but if you go into ChatGPT or you're going to DALL-E and you create an image, can you go copyright that image with the Copyright Office? And this is still going back and forth, and I think that Tyler probably knows more about this than I do. But the rule, the last time I've looked at this, and it's changed, is that you cannot copyright something that was created by AI unless you have a significant level of contribution, personal contribution to it. And I think this is going to go back and forth a lot. So the last time I saw it, the reason that it was a comic book, but the reason that they were denied copyright after actually gaining copyright the first time around was because the person posted on their Instagram or Facebook or whatever it was that, look what I did using 100% AI. And the Copyright Office saw it and went back and said, sorry, you didn't do this yourself. But if AI is simply being used as a tool, of course you can copyright. It would be like, I can't copyright something that I created on Canva. Of course I can. So it's that significant contribution level. But this is going to go back and forth, and we're going to see a lot of cases.
The laws are evolving. There's new legislation. It is an unsettled area of the law, although the Copyright Office recently has given more guidance on this. Tyler, you agree?
Under this administration?
No.
Well, the most recent case with Thomson Reuters, yes, the court found that the machine learning was not fair use. So I think we're going to see a lot of cases coming in down the pipeline. There are so many cases in the courts right now. Look, I think this is something that is incredibly, incredibly contested and being scrutinized. I mean, I'm about to speak at the MIT AI Summit in a few weeks. I actually thought it was a mistake when they invited me. I said, well, I'm not an AI expert. And they said, we understand that, but we want someone who is a protector and champion of creators to come talk about the creator's point of view and how do you protect IP. I will be speaking against or with the Deputy General Counsel of Anthropic, who has a very strong position that this is fair use. We've already had 2 pre-panel talks. It's going to get pretty heated. Anyone who's going to be there, it's going to be a great conversation. But realize that the developers, or at least MIT really wants to hear from creators and from the IP holders and understand, well, what is your position and why do you think it's not fair use? For me, if you're not giving credit and compensation to the creators, then there's an internal, unfairness to that. And perhaps that's 2 different conversations, right? Fair use versus fairness. Okay. But all of these things are.
Remember,
really
we're going to have Ask Me Anything in a minute. So quick.
I want to piggyback. The last time there was a major update in the Copyright Act was the Digital Millennium Copyright Act, which was what? 2000, early 2000s?
Yeah, 2001, I think.
We're in 2025. Anybody at the Copyright Office and the legislators need to figure out at some point pretty soon that there needs to be an update to what the legislation is. Before that, it was 1976, and before that, it was 1960s.
All right.
They take a while, so
really
we'll see what
quickly,
happens.
someone gets a notice of takedown. They are on TikTok, YouTube, other platforms. What should they do? And they think it's wrong.
Well, they have to appeal it, right? And they have to go contest it with the IP holder. Here's the thing. YouTube and the platforms do not want to get involved anymore. They used to, but now there's literally millions of IP strikes or demonetization that happens. So YouTube has said, you know what, you guys go figure this out. And I have had clients lose their channels. I've been able to get it back because at the end of the day, you go to the IP holder and you say, what do you need to make this right? I've had people say, pay me, give me credit, just at least acknowledge that you've used my IP, and we've been able to get those strikes removed. As Eric says, what we do, and I teach my young lawyers this all the time, the law is actually a small part of what we do. It's actually about human relations and what does the other side need.
Okay. All right. In the remaining 2 minutes, let's quickly, you guys, just go round robin style. Last minute tips for this wonderful audience who's come out today.
One tip, join the Creators Guild of America. Small plug, I'm the chair of rider advocacy, but basically they are implementing a rider that they can attach to contracts that have all these basic protections we've been talking about: indemnity, training on AI, you owning your materials, free organization to join, and for any brand partners that they have, there's a massive announcement coming next week. that you can get all those protections by just asking for it to be attached to your contract, and they have to do it.
What other tips? Study some of this stuff. Learn your craft, right? No matter what you're doing, if you're film and you're in traditional, you're in alternative, learn. This is just part of being in the business of being a creator. The only difference is, and Rob Ryan's here, I think he's speaking on the next panel, he talks about this stuff as everybody is an individual production company. We've been moving towards this for, several decades. And now that you're an individual production company, you've got to have the legal side and the business side and the production side all in line. So in the same way you need to have the accountant, you need to have the legal service, etc. Just learn your craft as a business owner. Individual creators are business owners, and that's the point. And I think that
Tyler gets the last minute.
I will say, if you are a creator, you are a future head of a studio. I almost sold one of my clients' channels for $35 million last year, you guys. And I have Hollywood producers asking me, how can I buy a channel? This is the future. And you need to think of yourself beyond a content creator, right? You need to have 8 to 10 revenue streams. You need to think about yourself as a media company. And like Eric says, I think it's not just the future, it is the present. It is a $500 billion industry, according to Goldman Sachs.
Yeah.
And I think the fact that there's a creator lab at NAB really signals how big this space is and will keep growing.
Can I take the last 5?
Get 60 seconds to wrap it up.
Okay, you got it. What Tyler just said is you've got to have multiple streams, because if you get kicked off of YouTube, you've got to have your newsletter, you've got to have TikTok, you've got to have something else. Just happened to somebody I know off of Instagram. They $250,000, their entire income stream gone. Got to have the multiple channels, like she's just said.
I would like to thank Jim and our panelists, NAB and the Creators Lab, for giving us 30 minutes to cover a topic that could be days. Join us afterwards, and if anyone wants to give me their information, we have materials to provide.